pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you all for coming and attending our May 13, 2024, 7 p.m. meeting. Actually, a special board meeting. And we will start off with the resolution decision rendering in the matter of the hardship application of 61 East Main Street Associates LLC. During this particular portion, there is no public comment, just as a heads up to everybody, okay? Excuse me 1 second for allergies. You guys ready? A special meeting of the Village Board, Village of Washingtonville, New York, was convened on May 13, 2024 at 7 p.m. The following resolution was duly offered and seconded to it. Resolution denying the hardship variance application of 61 East Main Street Associates LLC. Whereas on or about December 28, 2018, applicant 61 East Main Street Associates LLC applicant submitted a site plan application, the planning board application to the Village of Washingtonville Planning Board, the Planning Board, for 61 East Main Street, 61 East Main Street, Washingtonville, New York, the property. And whereas the property consists of 2 tax parcels, one which is wooded, undeveloped, and in a designated wetland area. And whereas on or about August 23, 2019, applicant submitted a significantly revised site plan in connection with its planning board application. And whereas applicant would need to seek at least 2 variances from the Village of Washingtonville Zoning Board of Appeals, the Zoning Board, in connection with the planning board application, including an area variance of minimum lot size per dwelling unit, and a variance to allow parking to be between structures. And whereas on June 24, 2020, the village filed suit, the 61 East Main Street lawsuit against, amongst others, applicant because defendant were using the property as a boarding house without proper approvals and permits. And whereas on September 22, 2020, the village and defendants, including applicant, entered into a stipulation of settlement, the stipulation resolving that 61 East Main Street lawsuit, in which the parties agreed that the planning board application is or shall be caused to be in compliance with the provisions of the Village of Washingtonville Code unless specifically otherwise authorized by the village. The project contemplated by the planning board application shall be constructed and or utilized in accordance with the applicable village code provisions, and the village shall review the planning board applications to a conclusion diligently in good faith. And whereas the planning board was not a party to the 61 East Main Street lawsuit, and such as a separate legal entity, the village could not bind the planning board to review the planning board application to a conclusion diligently in good faith. And whereas as of May 15, 2023, the planning board neither issue a negative declaration under this State Environmental Quality Review Act, SEQR, for the planning board application nor approve the planning board application. And whereas of May 15, 2023, the zoning board had not granted any variances in connection with the planning board application. And whereas on May 15, 2023, the village board trustees, the board, passed Village Local Law Number 2 of 2023, the May Moratorium Law, which was filed in New York Department of State on May 17, 2023. And whereas the May Moratorium Law provides no land use approval shall be issued for any use or development in the districts within the village without the approval of the village board and of the Village of Washingtonville, which approval shall not be considered except in the event of a proven hardship. The village planning board shall not accept any application, grant any approvals, issue any determinations, or continue the review of subdivision plat, site plan, special exception use permits, or other permit that includes the permitting, construction, and/or development of any use in any district within the village would have a result of an enlarged relocation or modification of any existing use and. Whereas the May moratorium law defined land use approvals as building permits, certificates of occupancy or completion, site plan approval, subdivision plats, special use permits, area and use variances, and architectural approvals. And whereas the May moratorium allows any person or entity subject to the May moratorium to seek a hardship variance from the board. And whereas on November 20th, 2023, the board passed local law number 8 of 2023 collectively with the May moratorium law, the moratorium law, which was filed with the New York State Secretary of State on December 14th, 2023, in which extended the moratorium through May 31st, 2024. Whereas the board anticipates it will pass on one or more extensions of the moratorium on or before June 1st, 2024, and such the board anticipates that the moratorium will end no later than December 1st, 2024. And whereas on May 6th, 2024, the board set a public hearing for the May 20th, 2024 for a 6-month extension of the moratorium law. And whereas no party has filed an Article 78 action to challenge the moratorium, and whereas Section 7B of the moratorium law does not allow a person or entity to obtain hardship variance under the moratorium law because of the mere concern that the regulation may be changed or adopted, or that the comprehensive plan may be amended, or the mere delay in being permitted to make an application or waiting for a decision on the application for a variance, special permit, site plan, subdivision, or other permit during the period of the moratorium imposed by the moratorium law, or financial impacts that may result from the applicant's desired project being potentially precluded by zoning changes and required development of the project of less value. And whereas under Section 7E of the moratorium law, the board must examine the following 3 criteria in determining whether to grant a hardship variance: the extent to which the proposed development activity would cause significant environmental harm, adversely impact surrounding natural resources, public health, comfort, or safety concerns, and/or have a negative impact upon the village. Whether the moratorium law will expose a property owner or applicant to substantial monetary liability to a third person, or would leave the property owner or applicant completely unable, after a thorough review of the alternative solution, to have a reasonable alternative use for the property. And the extent to which the property owner presents proof demonstrating severe financial hardship, it demonstrates, and such property owners cannot achieve any reasonable return on the property in question as a result of the moratorium law. And whereas on and about January 26, 2024, applicant submitted the application to the board, which is incorporated herein by reference. And whereas in the application, applicant made the following arguments for why the applicant satisfies the criteria for the board to grant the application. Moratorium law 7B, rationale for applications that preclude a finding of hardship. Not granting the application will violate the village requirement to review the planning board application in good faith and result in litigation. Applicant purportedly suffer significant financial loss if the project is not exempt from the moratorium law. And Governor Hochul's mandate requires the village to provide more housing in the village. And moratorium law 7E, proposed development impact on the environment, safety, comfort, and village. O&R zone allows the project. The project is surrounded by a mixture of commercial and residential buildings. On April 25th, 2023, the planning board purportedly on the cusp of issuing a negative declaration under seeker demonstrating lack of the environment impacts on the village, and the moratorium law 7EB, substantially monetary liability, no reasonable alternative use for the property. Applicant has made investment into the project to date of $1,426,180.27, and will have made investments of $7,626,180.27 when the project is built out. The project, when fully constructed, will have a value of $10,500,000. The property is worth $670,000 without approval sought by the planning board application. The property is worth up to $950,000 with the use exempt from the moratorium law. In the moratorium law 7EC, severe financial hardship, for this prong, the list of potential uses to be considered are those are permitted while the moratorium law is in effect. And because the maximum value of the property is $950,000, without planning board application, applicant will face financial harm. And the property has no value because of the moratorium law. And whereas in application, applicant failed to provide any documentary evidence of this investment into the property or losses purportedly incurred because of the moratorium law. And whereas on March 4th, 2024, the board set the hearing for the application for April 15, 2024. Whereas on April 8th, 2024, despite arguing in the application of the granting the application would avoid unnecessary litigation, applicant filed suit, the federal suit, against the village and the board in federal court before the board could hold a hearing on the application. And whereas on April 15, 2024, the board held a duly noticed hearing regarding the application, a transcript of which is incorporated herein by reference. And whereas one applicant, two, Charles Gottlieb is the Esquire applicant's attorney, 3, Michael Morgante, PE applicant's engineer, and 4, Phil Greeley, applicant traffic engineer, appeared at the hearing on behalf of the applicant. And whereas Mr. Gottlieb gave applicant's version of the background of the application, including that the project has been before the village since 2020. As of April 25th, 2023, the planning board purportedly was closed to issuing a negative declaration under seeker, and the May moratorium law prevented the planning board from issuing a negative declaration or approving the site plan. And whereas Mr. Gottlieb reiterated the same arguments as the application for why the board should grant the application, whereas Mr. Morgante and Mr. Greeley presented the presentations regarding the site plan traffic issues during the hearing, and whereas the public comment regarding the application was unanimously opposed to the application, including concerns the applicant's traffic study did not take into account of high volume traffic on Route 94, such as 3 p.m. on school days and other times of high congestion. The project would place significant stress on Route 94 by adding significant number of additional vehicles. The additional stress on village roads would exacerbate existing difficult emergency services having to travel to emergencies, and the project design does not fit within the character of the village in its proposed location. And whereas the board makes the following findings and facts. Seeker, the application is a type 2 action under seeker pursuant to 6 NYCRR 617.5 C 26 and 36. 7B of the moratorium law precludes any finding of hardships where the applicant A, has a mere concern of the regulation may be changed or adopted, or that the comprehensive plan may be amended. B, complains that mere delay in being permitted to make the application or waiting for a decision on the application for a variance, special permit, site plan, subdivision, other permit during the period of the moratorium imposed by the moratorium law. Or C, may suffer financial impact that may result from the applicant's desired project being potentially precluded by zoning changes and requiring development of the project of lesser value. In the application and hearing, applicant contended that the value of the property is no more than $950,000 because the moratorium, yet it has currently invested $1,424,180.27 in the project. Applicant's real estate appraiser contend that without the moratorium in effect, it is current condition, but will have all approvals, the property value is $1,260,000. The moratorium law is a stopgap measure pending the conclusion and revisions of village comprehensive plan and co-commitment rezoning. The village anticipates that the process will be completed by the end of the year. Once that process is complete, the moratorium law will be lifted. Applications will be able to proceed to the planning board applications. Applicant alleges financial loss because it is unable to carry forward with the project as proposed by the planning board application. Yet applicant fails to demonstrate any damages arise from the moratorium itself, rather than a delay in consideration of planning board applications, or 2, a concern that post-moratorium law applicant will be forced to modify the planning board application. The board finds that the applicant arguments to the contrary are unavailing. First, the applicant claims that the moratorium law violates the stipulation of granting the application will avoid unnecessary litigation. At the threshold, the applicant's federal lawsuit believed the argument unless sole purpose of the file of the federal lawsuit was compelled by the board in granting the application. Moreover, the board finds that the planning board application is or shall be to be in compliance with the provisions of the Village of Washingtonville Code. The moratorium law is part of the village code, and by the express terms of the stipulation, the planning board application must comply with the code. The board complies with its requirements to entertain the planning board applications by hearing this application and provide for let me back up on that. Application as provided for in the moratorium law. Second, applicant claims that it will suffer significant loss if the project is not exempt from the moratorium law. The board notes that the applicant failed to detail what financial losses will incur if the application is not granted, apart from 1, loss from the delay, and 2, concern that the planning board application will need to be modified post-moratorium law. Third, the board finds that Governor Hochul's proposed housing compact does not apply. Applicants ignores that Governor Hochul scrapped the housing compact. The housing compact never became binding law that affects the village. Accordingly, the board determines that the applicant solely, 1, complains on the mere delay in waiting for a decision on the planning board application during the period of the moratorium law, and 2, claims that may suffer financial impact that may result from the applicant's desired project being potentially precluded by zoning changes and required developments of the project of lesser value. These concerns are not any different than those experienced by other potential developers who desire to build in the village. Section 7EB. Section EB requires that the board determine whether the moratorium law will expose applicant to any substantial monetary liability to a third person, or would leave the applicant completely unable, after a thorough review of the alternative solution, to have reasonable alternative use of the property. The board determined that the applicant has failed to propound evidence that the moratorium law will expose applicant to substantial monetary liability to a third person. The applicant contends that it has a SIC investor who has since dropped out due to the elongated permitting process and arbitrary actions of the village. Applicant fails to detail to the board the identity of the investor or provide corroborating information about the reasons and purpose investor asked to leave. Similarly, the applicant failed to provide the investment agreed to substantiate its allegation. The board is left to speculate on the reason this purported investor supposedly asked to leave the project. Finally, the applicant fails to document the $994,054.13 payment. Despite it being a very specific amount, the board is left with a bold, unsupported allegation from the applicant that this payment was made and was directly related to the moratorium law itself, rather than delay in processing the planning board application or fear that the subsequent zoning change will require changes to the planning board application. Removing the unsupported allegations of the investor payment, applicant has spent $432,126.14 to date on the property. Applicant real estate appraiser admits that as a remodeled house, the property could be worth as much as $950,000 through the allowable moratorium land use. Given this, the board determines that the use of the property as a house is reasonable or alternative use for the property. Section 7EC. Section EC requires the board to determine the extent for which applicant presents proof demonstrating severe financial hardship and demonstrates it cannot achieve any reasonable return on the property as a result of the moratorium law. The board determines that the applicant has not demonstrated severe financial hardship or that it cannot achieve a reasonable return on the property. As noted above, putting aside unsupported $994,054.13 purported payment to investor, applicant contends that it has invested $432,126.14 into the property, and based on the applicant's real estate appraisal statement, applicant could achieve $950,000 sale of the property under the moratorium law. Applicant in its real estate appraisal failed to detail how much the applicant would need to invest to remodel the house. Assuming large figures such as $350 means the applicant would invest approximately $785,000 into the property in total. That would result in a $165,000 profit, or over a 17% return. Additionally, the one case applicant cited to support the application, Montgomery Group LLC versus the town of Montgomery, 4 AD 3D 458 2D Department 2004, is inapplicable here. In Montgomery Group, the town of Montgomery board actively invited Montgomery Group LLC to invest over $4 million into a project that the town of Montgomery board ultimately rejected through a moratorium and zoning changes. There, Montgomery Group LLC submitted dollars and cents proof of its significant investment. Applicant has not done so here, failing to provide board with proof of its supposed investment into the property. Accordingly, the board finds that the applicant failed to present proof demonstrating severe financial hardship as required by the moratorium law, or that it cannot achieve a reasonable return on the property as a result of the moratorium law. Whereas the board, having completed its comprehensive review and consideration of the record, have fully deliberated thereon and has determined to deny the application for the reasons set forth herein. Now, be it resolved, Section 1, the above whereas clause as incorporated herein is set forth in full. Section 2, the board determines that this resolution is a type 2 action under seeker. Section 3, the board determines that under moratorium law 7B, the board cannot grant the application because applicant 1 complains of mere delays in receiving a decision on its planning board application because of the moratorium law, and 2, merely argues that it may suffer financial impacts that may result from the planning board application being potentially precluded by zoning changes and requiring development of the project lesser value. Section 4, the board determines that the denial of the hardship application will not expose the applicant to substantial liability to a third person or leave the applicant completely unable to have a reasonable alternative of the property under Section 7EB of the moratorium law. Section 5 determines that under Section 7EC, applicant may not provide proof demonstrating severe financial hardship or proof demonstrating that the applicant cannot achieve a reasonable return on the property as a result of the moratorium. Section 6, because applicant fails to satisfy the standards of Section 7 of Village Local Law Number 2 and 8 of 2023, the board hereby denies the application. Section 7, the board resolution shall effect immediately. A question of the adoption of the foregoing resolution was duly put to a vote on a roll call, which will result in as follows. May I have a motion, please?
Motion.
Motion Donna, second by Vernon. Questions or comments? None being heard. All in favor?
Roll call it, Tom.
Yeah. Roll call this one, please.
Roll call.
Mhm.
Okay. Have trustee Vernon Coleman, please.
Aye.
Trustee Steve Pressure.
No.
Hmm?
Roll call.
Roll call.
Is this roll call?
This is roll call for the resolution.
Trustee Susan Walski.
Yes.
Deputy Mayor Donna Giancaruso.
Yes.
And myself, Thomas DeVinco, yes. Okay.
Trustee Presser,
It's okay.
did your
Yes.
vote?
Sure, yeah.
No, thank you.
You're voting yes on it?
Yes.
Okay.
Okay. With the votes in, motion passes 5-0. Resolution thereupon is duly adopted. Thank you. And for the books, that was resolution 240048. Next is resolution 240049, resolution to authorize employment of a part-time building inspector 3 position. At a meeting, Village Board, Village of Washingtonville, was conveyed on May 13, 2024 at 7 p.m. The following resolution was duly offered and second to wit. Resolution authorizing part-time building inspector 3 position. Whereas pursuant to Chapter 124 Building Code, Administration and Enforcement of 128 Building Unsafe and Village Code, the Mayor and Village Board determined the appointment of Building Inspector 3 position to ensure safety of the Village of Washingtonville. Whereas the Village Board desires to authorize an appointment of a building inspector, now therefore be it resolved that the Village Board as follows. Section 1, the whereas clause are incorporated herein as set forth in full. Section 2, the Mayor, with the approval of the Village Board of Trustees, hereby appoints Timothy Ippolito to the position of Building Inspector 3 effective May 13, 2024. Section 3, the Mayor is hereby authorized to determine the assignment and delegation of tasks and supervisory structure of the building department as he deems appropriate. Section 4, the Mayor and any officer, employee, or consultant as directed by the Mayor is hereby authorized to take any and all actions to carry out the provisions of this resolution. Section 5, this resolution shall take effective immediately. The question of adoption and foregoing resolution was duly put forth to a vote. Roll call on which resulted as follows. Deputy Mayor Donna Giacoruso?
We need a
Oh, I'm
motion.
sorry, you're right, I'm sorry. Can we have a motion?
Motion.
Have a second, please?
Second.
Second, Vernon. Okay, now for the roll call. Donna Giacoruso?
Yay.
Trustee Susan Wolski?
Yay.
Trustee Steve Pressure?
Yay.
Trustee Vernon Coleman? And myself, Thomas DeVinco, yes. The resolution is hereupon accepted, duly adopted. Thank you very much. Okay. With that, there is no executive session.
Actually,
I'm sorry?
Mayor, I'd like to
Oh,
put a
you would?
motion for executive
Okay.
session, personnel matters.
Okay. So we have a motion to, yes, sir.
She already made the motion, so we're just looking for a
So I
second.
just need a second.
Second.
Okay. All in favor?
Aye.
Motion passes 5-0. Thank you guys very much, appreciate your time. We're just going into executive session, no decisions will be made in that area. When we come out, we'll resume the meeting and basically end it.
Close it.
We'll close the meeting, okay? Thanks for your time.
Thank you.
Thank you.